Bienenfeld Law with Saul Bienenfeld.
Hi, everybody. It's that time again, college time. And today I want to talk about something that has become one of the most important and sometimes one of the most misunderstood parts of campus life, being on a college campus. And that's Title IX. What it is, what it covers, and most importantly, what you should do if you ever find yourself accused of a Title IX violation. Whether you're a student, a parent, or just someone who wants to understand the process, this is for you. I'll give you a clear, unfiltered explanation, no scare tactics, no sugarcoating, just straight talk. Title IX is a federal civil rights law that has been on the books since 1972. At its core, it says this: no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Over the years, that single sentence has been interpreted to cover a lot more than just equal sports opportunities for women. Today, Title IX is the framework schools use to address sexual harassment, sexual assault, dating violence, stalking, and gender based discrimination. If a school takes federal money, and almost every college and university in this country does, they are required to follow Title IX rules. They have to investigate reports, hold hearings, and in theory, protect the rights of both the person making the complaint and the person accused. So here's what usually happens when a Title IX complaint is made. It starts with a report to the school's Title IX coordinator. That could come from the alleged victim, a friend, a professor, or even a staff member who feels that they have an obligation to report. Once the complaint is in, the coordinator decides whether it falls under Title IX, and if it does, the accused student, called the respondent, will get a notice of allegations. This is the moment the process becomes real. From there, an investigation starts. That could include interviews, collection of evidence, reviewing text messages, social media, emails, anything the school thinks is relevant. The rules require that both parties have a chance to review the evidence before a hearing. If the school holds a hearing, each side can present witnesses and evidence. And under the current rules, cross-examination happens, but through an advisor, not directly by the students themselves. When the hearing ends, the decision makers issue a finding, either responsible or not responsible. If found responsible, the penalties can range from a warning all the way to permanent expulsion. There's usually an appeal process, but that window is very short. If you ever find yourself on the receiving end of a Title IX complaint, here's what you have to know. You have the right to a written notice of the allegations before any interview takes place. You have the right to an advisor, and that advisor can be a lawyer, such as myself. You have the right to see all the evidence, even evidence the school doesn't plan to use. And you have the right to cross-examine witnesses through your advisor or attorney. But here's the reality. These cases move fast, and schools are under intense pressure to show they take accusations seriously. That pressure can sometimes mean the process feels tilted towards the accuser and against the accused. That's why asserting your rights early is not just important, it's essential. If you get a notice of allegation, your first instinct might be to tell your side of the story right away. Don't. Instead, take these steps. Number one, get legal counsel immediately. Even if you think this is just a school matter, the stakes are high. Expulsion is life-changing, and statements you make here could affect a criminal investigation later. Two, do not contact the complainant. No calls, no texts, no let's work this out. Even indirect contact through friends can be used against you. Number three, preserve all the evidence. That means screenshots, text messages, emails, even location history from your phone. And four, write down your timeline. The sooner you do this, the clearer your memory will be. If the case goes to a hearing, preparation is everything. Work with your advisor to create a theme for your defense. This isn't just about facts, it's about credibility. Identify witnesses who can support your version of events, review the evidence carefully, anticipate the questions the other side might ask, and prepare your answers. Remember, the standard in Title IX cases is preponderance of the evidence. That means more likely than not. It's a much lower bar than beyond the reasonable doubt standard in criminal court. And that's why every piece of evidence matters. A Title IX finding can follow you far beyond campus. Academically, it can mean suspension or expulsion. Professionally, it can cost you internships, job offers, or licensing opportunities. If you're an international student, it can affect your visa status. And there's always the risk that a parallel criminal case could be opened. And that's why these cases need to be handled with the same seriousness as a criminal charge. If there's one takeaway I want you to remember, it's this: don't go through a Title IX case alone. The system is complex, the stakes are high, and the process can be unforgiving. Understanding your rights, protecting your evidence, and getting the right help can make the difference between clearing your name and carrying a permanent mark on your record. Title IX exists to protect students, but it's also a system you have to navigate carefully to protect yourself. That's it for today. If you found this helpful, please share it with someone who might need it, might need to hear it. Share it with parents whose children are going to college. You never know whose future you might be helping. Thanks for listening. Until next time, stay informed, stay prepared, and take care of each other.